Swayam Prabha. Digital India. Educated India.
Dear students, I am going to take second lecture in the subject of Transfer of Property Act. Myself, Dr. Amarendra Kumar Ajit, Assistant Professor of Law, Senior Grade from Faculty of Law, University of Delhi. This is the second lecture of Transfer of Property Act. In previous lecture, I discussed about the concept of property, types of property, movable and immovable property definition, and interpretation by various courts, that what fall under movable and immovable property and actionable claim. Now, I am going to discuss about transfer of property, which is given under section 5 of the Transfer of Property Act. So, this whole lecture will be devoted to this three term transfer of property, three words. So, why this is so important in this class or this lecture, that the whole act itself talks about the transfer of property. Then the importance become very important one, that why or what may fall under this transfer of property, what will be included under transfer of property, what will not be included under transfer of property. So, first I will go through the statutory provision which has been given under the Transfer of Property Act, they are essential, and then after various judicial decisions in which something has been said as transfer of property and something has not been said as transfer of property. So, we will see about all these things. Before that, just I will give you a brief analysis about the scheme of the Transfer of Property Act. In detail, I have given the whole act analysis or scheme of the whole act in the previous lecture. This is about only the chapter 2. So, chapter 2 can be categorized into two parts, part A and part B. Part A provides for the rules regarding transfer of property in general, whether it is movable or immovable, whereas part B provides rules regarding transfer of immovable property. Okay. So, part A is mainly for any kind of property, whether it is movable or immovable. If you will go through the part A, then you will find that it has been defined that what may fall under the transfer of property, what may not fall under, what can be called as a transfer of property, then what are the conditions for the transfer, whether it is what are the vested interest, contingent interest, then rights of the unborn child, all these things we will see in the part A itself. So, I will start with section 5. Okay. Section 5 is the definition part, which talks about which gives the definition of transfer of property. Section 5 says that transfer of property means an act by which a living person conveys property in present or in future to one or more living persons or to himself and one or more other living person, and to transfer properties to perform such act. Then after going through definition, you will find 4 essential for the transfer of property. What are those 4 essential? So, first is transfer of property is an act of conveyance. Okay. First is this itself. That means, transfer of property itself is a kind of transfer. Conveyance means a kind of transfer. Who can transfer it and to whom it can be transferred? So, it has been said that a property may be transferred by a living person to a living person, okay, by a living person to a living person, and himself also. A person can transfer his property to himself. We will see all this when I will discuss the second essential, that how a person can transfer to himself. Third is that property may be conveyed either one or more other living person, and fourth is that this transfer may be for future also and may be in present also. So, now come to one by one these four essential. So, first is about the act of conveyance. What is the act of conveyance? Okay. The first essential is that property must be conveyed. What is the meaning of this conveyed? Conveyed means it must be, property must be handed over to other people. Other people, that means other living person. So, property must be handed over to other person, that is this first essential itself is about the transfer. Transfer means the things are going from one hand to other hand. Okay. But here in case of immovable property, how the immovable property will go from one hand to other hand? Property is going to remain at the same place. In movable property, it is very visible that once you will transfer something, if you will transfer the movable property, just like in the sales of goods, then the goods will go from the one person to the other person in hand. But it is not possible in the case of immovable property. Immovable property are situated at a place which cannot be moved. Then what is going to be transferred? This is the transfer of the rights related to that property. Okay. This rights related to that property, that the enjoyment right of that property, ownership right of that property is going to be transferred. Property will remain at its own place. So, the person who is trying to convey the property, he used to transfer the rights of ownership from himself to the other living person, or in certain cases himself also. Okay. Then document of transfer must show the change of ownership. That is, that once it is going to be transferred, then how it will be transferred? So, there are requirement of certain procedural requirement, statutory requirement, that ownership must be changed on paper, okay, and in that way rights of that property, that right related to that property has been transferred from one person to other person. Next important important thing is that under this act, conveyance of property may be affected in one of 5 ways. What are those? That you may transfer your property through sale, mortgage, lease, exchange and gift. Sometime it may be complete transfer, and sometime there will be certain kinds of transfer with related to that particular certain rights, just like in the case of mortgage. Okay. In mortgage there is no change of ownership, but there is a change of possession, change of right to enjoyment of that property. Okay. So, in that way we will see it. So, the next important point is conveyance by living person. Who is living person under this act? Living person means what? Only natural person or general living human being? No, this notation of the nomenclature living person is very broad. Very broad means it includes natural person as well as legal person or juristic person. Okay. So, living person can transfer his or her property to another living person or to a company or to a corporation or to a society, registered society, in that way. Okay. So, it will be also amounted that it is between the living person. For a common man, a building may not be living person, a society may not be living person, okay, corporation may not be living person, they are the legal person. But in law, in case of Transfer of Property Act, they are treated as living person. So, transfer is possible between two living person, that means between two corporations. Actually, there is no involvement of any legal person, there is involvement of only legal person, but it will be also treated as transfer between two natural person if there is a transfer of property between two corporation. In the same way, in case of merger, in case of acquisition, okay, what used to happen? There is agreement to sale of property or merge of the property between two corporations, okay, but it will be also governed through Transfer of Property Act. Then about the juristic person, in case of Shiromani Gurudwara Prabandhak Committee Amritsar versus Sri Somnath Das, the court said that the juristic person can be an individual, firm, corporate company, association, society, okay, not including a partnership firm. So, those who want to bring a suit against any person or against any corporation, in that case this essential element of living person is very important, that it must be transferred from one living person to other living person, that okay, and in that way it works. That means a living person can sue the other living person, or a living person can be sued by the other living person. That means a corporation can sue to individual, and individual can sue the corporation, individual can sue the individuals. So, that is not a problem at all. So, in case of Har Narayan versus Bank of Upper India, okay, it is of 1938 case of auth. The court held that a court is not a juristic person. This is a very old but very important judgment. A court is not a juristic person for what purpose here? Okay, that it is not a living person either. Therefore, a court order for sale is not a transfer of property within the meaning of this act. Okay. So, court has been created by a statutory provision or through the Constitution of India, but the decree what they are granting, the decree effect is that it is a kind of transfer of property, but actually legally it is not a transfer of property. It cannot be said that this is an agreement or this is a kind of things through which the transfer of property is going to happen. Why? Because court had said that court are not juristic person. Calcutta High Court also held that an unregistered society, unregistered, not registered, unregistered society, club cannot come within the definition of living person. That means, registered society will fall under the category of living person, registered club will fall under the living person if they are registered under the Society Registration Act, but if they are not registered, they cannot be treated as living person, and if they are not living person, then they will have no right to hold the property. It is not about the transfer. Who can transfer the property? The person who can hold the property. If you cannot hold the property, then you cannot transfer it. So, when the property, you are not, any person is not able to hold the property itself, there is no matter of transfer at all. So, court said in this case that any unregistered society or any kind of club or group which are not registered, they will not possess the right to possess the or own the property. So, there will be no question of transfer at all. Okay. Then next important point is conveyance to himself or himself with one or more other person. This provision was not earlier. Okay. In original act, this provision was not there. Why it has been added that a person can transfer his property to oneself? Thus, mainly that when a person, this amendment was brought only to cover the transfer of property to himself through trust, because the person who is creating the trust now transfer his all those property to trust and become the trustee of that property. So, prior to 1929 it was not possible, okay, that he can become the ownership or trustee of his own property, he cannot transfer himself. But 1929 amendment added the word himself within the definition of transfer of property. So, now person are eligible to transfer the property to a trust, and he can become the trustee of all his own property, and in that way he can manage his own property through trust. Okay. So, that is possible now. Next is transfer in future or in present. Okay. So, property may be transferred either with immediate effect or with certain condition in future, or in future if something will happen. So, this property can be transferred through this at immediate effect as well as in future. Now, come to the word property. Okay. Property in detail I have already discussed in lecture 1. Okay. That is, what is property, what are the kinds of property, and what are the subject matter of Transfer of Property Act, whether immovable, all these things has been discussed in detail in lecture 1. So, the term of property is a very broad under Transfer of Property Act, because it is include movable as well as immovable property. But keep in mind that whenever you are using the word property, then sense will come that something there is on which you can exercise your own right. Okay. So, any property is a kind of right, whether it is movable or immovable, and we have discussed also that the benefit which is going to be accrue from the this movable or immovable property, that will also fall under property itself. The nature of the property will be different if it is coming from immovable property, just like rent from the flat, then it will go under the immovable property. But if you are taking rent after renting your own car, then it will be movable property, but certainly it is a kind of property. Okay. So, definition of property is very broad under this act itself. Then we have gone through the different kinds of or category of property: movable, immovable, tangible, intangible. These days, one of the important aspect of property has emerged and now leading in the knowledge based economy, and that is called intellectual property. Okay. So, this intellectual property is also a kind of intangible property, that is, which is not visible. The person or owner, that is author or owner of intangible property, are possessing those rights, exclusive right, that other party cannot infringe, and that is also a kind of property right. But this has been the rights related to that has been defined under different IPR laws. But once the transfer matter will come with related to that, then they are also governed through the immovable property, like immovable property. They are intangible immovable property. So, their transfers are also governed through Transfer of Property Act. Just like take the example of transfer of this trademark, transfer of patent, okay, transfer of copyright. So, all those things are intangible in nature, okay, but because this is the kinds of right which is intangible and governed through this act itself. Then property itself is a bundle of right. Property itself is a bundle of right. Generally, it has been categorized into three specific feature of any property, but except in addition to those three specific feature, that means possession, ownership, and right to use, up to that extent that alienation. That means you can possess it, you can own it, and you can sell it. Okay. In addition to that, there are others right which are also available to related to that property to any owner. So, number of kinds of right you can use through the property rights. Now, there are various concepts whether that will fall under the category of transfer of property or not, and that is very important. This concept generally used to be asked in examination through different problems that try to identify that whether it will be a kind of transfer of property or not. So, first case come with the partition, whether partition is a transfer of property or not. Okay. So, first of all, what is this partition? What we are talking about the partition? Partition means going to do the part of the property. For what purpose? That means you are going to share it. That means there are number of co-owners of that property, okay, and there is a division of property between the co-sharer. So, when you are going to divide the property between the co-sharer, whether it will be called as a transfer of property or not. So, generally first of all it has been written that transfer of this partition does not fall under the category of transfer of property, but the reasoning is very simple and unique also, because once you will understand this concept, then more or less in coming concepts it will be very clear and you can easily identify that whether that property that kind of things or concept will fall under the category of transfer of property or not. So, first is partition. Okay. Why this partition does not fall under the category of transfer of property? The basic reasoning is very simple, which has been given by the Supreme Court also and followed by the various high courts. Before this judgment, that is 1988 judgment, you will find the number of judgments on this subject matter or issue by various high courts, where there was the varying opinions. Some were accepting partition as a transfer of property, and some high courts has adopted that it is not a transfer of property. Okay. So, ultimately in 1988 Supreme Court had said that it is not a transfer of property. Why it is not a transfer of property? Because the transfer of property means there must be transfer of the right, okay, to the from one individual to the other individual. We can now going to identify why it will not be. Take the example first of all, that in a house, ancestral house, if 4 brothers are residing in that house and after death of their father, they want to partition it, they want to divide it. Okay. It is then what they will do? They are going to divide only the same house with different rooms to identify that okay, they will remain in this, that portion will be their own portion and other portion will be of the other's brother, another brother. So, in that case property was which was actually in a joint ownership type, now it has been this partition and possession has not been transferred, ownership has not been transferred. Why? Ownership has been only shared. Okay. That means which was under this share under unitary sharing, now it has been partition sharing. That means now I will be the owner of this part. So, there is no transfer of property, rather than only this is the partition of property. So, new property is not going to come in the hand of all 4 brothers. Okay. New property is not going to come, they are not going to give the property to others also, another person. What they were using? The same property they are going to use even after partition. So, transfer is not happening in this case, there is no conveyancing in this case. So, Supreme Court observed that the partition is not actually a transfer of property, but would only signify the surrender or a partition of a joint right in exchange of a similar right from the other co-sharer or co-shares. Okay. So, this is very important one, that it is a kind of only signify the surrender or a partition of a joint rights in exchange of a similar rights. So, this is mere exchange between a closed group. When there is a closed group and between that you are sharing it, then it will fall under the partition and not come under the category of transfer of property. The Karnataka High Court also will explain by saying that partition is not a transfer. Okay. The reason being that no conveyance is involved because everyone had an antecedent title. Okay. Everyone, because earlier before partition what was happened, everyone has title over that property. So, it is not a transfer at all. Okay. Then next question is about dissolution of partnership and distribution of assets amongst partner. Okay. Partnership is actually a creation of the partners through agreement and is governed by the Partnership Act. So, what happens in this case, that in case of partnership, all partners are entitled to equal share and equal rights subject to the condition of the agreement. So, if all are of the equal right, then the same type of reasoning will come like the partition here also. What it says, that if all partner will have equal right on in a firm, so all will have equal rights, equal duties, equal obligation. Then and for a joint purpose, and the main purpose of partnership is that means whoever is working, they are working for the benefit of the partnership firm. So, once there is division or distribution of assets among the partner at the time of dissolution of partnership, then it cannot be said that it is a transfer of property. Why? The partners are going to take only those assets what they were using during the partnership firm. Okay. So, same reasoning of partnership will apply here also. So, it was held in Balbir Singh versus State of Uttar Pradesh. It is a 2012 judgment of the Allahabad High Court, saying that the distribution of assets of the firm and the receipt of the respective shares by the partner does not amount to transfer of property. That means, any partner once started the dissolution proceeding of the partnership firm. So, all are going to get this with the consent through agreement, all the shares, and whatever they did they will make or receipt they will get it, that will be not the proof of transfer of property. So, it will be not amounted as transfer of property, and it will not amounted as transfer of property means the rule of Transfer of Property Act will not apply on them. Okay. Then court also found that there was no assigned or definite share of partners in movable or immovable assets during the subsistence of the firm. Share in the property are assigned to partners on dissolution on the basis of their share in the firm. Okay. So, whatever the share in the firm it was, according to that it has been divided. So, the deed of dissolution and consequential deed by release could not be treated as conveyance, because releasers have no right to property at the time of release. So, very important thing is that what they are going to take in their own part according to the agreement of the partnership. Suppose I had 30% share. So, once the assets will be divided, then out of all assets, once it will be calculated in the price form, then I will be entitled only for the 30% of the assets, okay, and that will be given to me. So, in that way, whatever I am going to take as an individual partner after dissolution of firm, the same thing is going to come which I was using earlier during the partnership firm. So, in that way it will be not called as a transfer of property from firm to a partner or ex partner. Okay. So, in that case this partnership, dissolution of partnership or any instrument related to the dissolution of partnership and the distribution of assets among the partners will not fall under the category of transfer of property definition. So, Act will not apply in case of dissolution of partnership. Clear? Now, next is surrender. Okay. First of all, what is surrender? Surrender is a kind of things, that means kind of way of doing things, that you are going to relinquish your right. You are going to deposit whatever you had, now you are going to deposit into the main one. So, surrender is a merging of lesser interest in the greater interest. Okay. Surrender is merging of lesser interest into greater interest in such a manner that the greater interest is not enlarged. Okay. Greater things are not going to be enlarged. So, take the example of this partnership firm itself I will give you, because it will be easy to understand, because we have just discussed it. So, suppose one partner is going to surrender his partnership right. Okay. Then what will happen? It overall firm rights are of certain value. This value, which is belongs to a particular partner, they are going to surrender it, that will remain same. Same way it happen in the case of company. Okay. If the shareholders of the company, they are going to give that shares to the company, surrendering those shares, in that case what will happen? The company total number of share is not going to be increased, it is falling within that overall maximum limit itself, and in that way there is no change in the larger interest. So, surrender is also treated as not a transfer of property under section 5 of the Act. So, reason is very clear, because now it is just opposite to the partition. In partition, we are not going to take something new from the existing pool of things, okay. And in case of surrender, we are not going to increase something more in the pool of things. Okay. So, in that way, surrender is not increasing something and partition is not decreasing something. The overall things are going to remain same. So, here it, in case of surrender also, it is not treated as transfer of property. So, in Makhanlal Laha versus Nagendranath, Calcutta High Court said in 1933, the surrender of a lease is not a transfer of property. Where there is a surrender of lease, that means you are now surrendering the lease to the owner, then the ownership right is not going to get certain new things more. Ownership had a total right over that his property or her property. He has leased that property to you, and now you are surrendering those rights to the owner. Owner is not going to get new things in that. So, in that way there is no his property is coming to him only after some time after or due to the surrender of this lease. So, overall it is not increased at all. So, in that case it has been treated as not a transfer of property. So, surrender of a life estate by a Hindu widow is not a transfer, okay, since it amounts to an act of self effacement by the widow and accelerates the succession to her husband's estate. It has been told by the Supreme Court in 1954 in Natwar Lal Punjab Bhai versus Dadu Bhai Nanu Bhai. Okay. That means, surrender of a life estate by a Hindu widow is not a transfer, because whatever it is going to come in that family, that was the part of the family itself, and later on it will be divided into succession. So, there is no problem at all. What was the